Hello, this is Matt on the Moon Family Sedan channel. We've been waiting almost 5 whole months for this, and today we have it. What am I talking about? It is the transcript of the January 30th, 2023 motions hearing on remedies in the SEC v. Library case. Now, this is relevant if you're an XRP holder or hold any crypto, period, because attorney John Deaton ended up getting amicus status in that case, not just the SEC v. Ripple case, but also the Library case for the remedies portion after the SEC defeated Library in November, I'm sure you'll recall. And so this is the remedies portion at the end of January. And we knew the types of things that were discussed because attorney John Deaton had disclosed that and he was allowed to do that. But what we didn't have until today was the actual transcript. And this is highly consequential because what's happening here sets precedent, even if it's not a legally binding precedent necessarily. It's going to sway the way that things go. It's going to impact other judges' decision-making process. And we know that from this, that the judge in the Library case here has indicated that secondary market transactions are not part of his ruling, even though Library lost. This is of critical importance for XRP holders, because even if Ripple loses, which is possible, what we need as XRP holders is for there to be a path forward for XRP, for secondary market transactions to be allowed, and ideally for Ripple to still be able to buy and sell XRP, at least for on-demand liquidity purposes, bare minimum. And so John D, it's just incredible what he's done, and at his own expense. He's not getting paid a dime to do this stuff. It's costing him time and money. And he's just doing it because he's got the fire in his belly, and I couldn't be more thankful, and I know that all of you out there listening feel exactly the same. So I'm going to cut to the chase on this thing here. It's actually 65 pages, and I don't need to go through all of it to kind of make the point. I'm going to cut to the chase and get to the heart of the matter and show you exactly what happened, because I'll tell you this right now. Without John Deaton, we would not have this clarity in this case. That is a certainty. John Deaton did this, and it's good for us as XRP holders. Judge Torres is going to be aware of this in the SEC v. Ripple case. So let's go ahead and hop in. But before I go further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Shout out and credit to John Deaton's crypto law organization, which shared this document. Now, there's an XRP community member named Ashley Prosper who shared the most relevant portion, which is what I'm going to run through with you here today. And then I got a quick comment from attorney John Deaton on this as well. And so Ashley Prosper wrote the following. The transcript from the Library hearing, which John Deaton attended, is now available. John is amazing and does indeed get the judge to agree that his ruling did not include whether LBC tokens themselves were securities, and that his ruling did not apply to secondary sales. And I'll just pause to note, one of the reasons that this is important, there are a number of reasons, is that the SEC, being the slimy little pricks that they are, those little asshats, they would absolutely try and take the judge's rule order, what he decreed here, out of context, and tried in future cases to point to this and say, see, look at these transactions. It's about all. They could easily do that. And so then Ashley Prosper says, the judge is also reluctant to grant any injunction against Library. I'm telling you, without Mr. Deaton, this crypto thing would be in big trouble. We owe him a debt of gratitude. It's so interesting to think all of the people out there that hate Ripple and or XRP because they're irrational humans, all of those people, all of those people are being saved because of what's happening, thanks to the efforts of attorney John Deaton, who is an XRP holder himself and very pro-XRP. It's not his largest crypto holding. He's publicly stated that. In fact, he said when the time the lawsuit came down, I'm pulling from memory here, but he the other day, he publicly stated on Twitter that I think he said that he had like 10 times as much Bitcoin as XRP and then like 4 times as much ETH as XRP. I apologize if I'm getting that incorrect, but I think that's about right. But the point is, XRP, it's something he likes. He's always had confidence in, but it's not his biggest crypto holding. It's just he really did go to bat here for the XRP community because we're the community that got attacked by the SEC and, of course, Ripple as well and the executives. And so let's go ahead. Here's a comment from John Deaton. He says, Hopefully, we will see a good ruling from the judge clarifying what he agreed to at the hearing. Although I truly appreciate the kind words, please remember Naomi Brockwell deserves the credit for having the courage to allow me to appear on her behalf as amicus. Yeah, so that's who Attorney Deaton was representing. And without somebody, in this case it was Naomi Brockwell, Attorney Deaton wouldn't have been able to play this crucial role that he did in the library case. And so let's go ahead and run through some of this. And Ashley Prosper is kind enough to highlight some of the most relevant portions here, which is most of what I'm going to touch on. And so here we have the first comment. I believe this is from Deaton. I'm not asking Your Honor to do the SEC's job, but I am asking Your Honor to clarify what you meant. And then the court responds, and when you see the court on the screen, that just means the judge. And so the judge says, I read that article before you put it in. Again, I didn't raise that stuff for the fun of it. It's something that I've been concerned about because it appears to me that certainly blockchain is a legitimate, important technology, and there's a need for tokens, and there are consumptive uses for tokens. And the evidence in my case was there are consumptive uses for LBC, that's its library credit token, that don't have anything to do necessarily with investment. So trying to be clear about how you address tokens of that type while still protecting the public from unregistered securities offerings is an important challenge. And I don't fully understand, this was a little dash there, pause, I don't fully understand the SEC's ultimate position on that at this point. So there we go. So even the judge recognized that the SEC is effectively, I mean, this is the way I'll phrase it, they're just not doing their damn job. They don't want to make things clear. What is their stance on all of this? What if something is, what if something does have utility purposes? What then? Well, crickets, right? And then there's this. The judge also says, they misunderstood my order as being something different from what it is. And then Attorney Deaton says, right. The judge says, and I understand why. I used the language of the case law, which is they offered LBC as a security. From that one statement, they construe my order to be saying, I think the tokens are security. And Attorney Deaton says, exactly. So pause. That's what I was saying a couple minutes ago. Because that was the language that was used in this litigation. And so the judge used that language at hand. And so you could misconstrue, if you wanted to, and take things out of context, if you're the SEC, and say that means that LBC itself is a security. They could make such claims, and they could draw to this as precedent even if it's not binding, because they're little ass-ass pricks. So you know they do that, right? Little monsters, spawns of Satan, right? And so here, the judge is acknowledging that. And Attorney Deaton agrees, of course. He said exactly. And then the judge says, when I'm saying, no, I haven't made that determination. That issue hasn't been raised in front of me. No one should understand my order as taking a position on an issue that wasn't briefed that I was thinking about, but consciously hadn't decided simply because I used the language of the case law that defines what an investment contract is. So that's my position on that particular issue. Okay, so there the judge is saying he's just using the language that was used in the litigation. Don't misconstrue it as meaning that LBC is a security, because that's not something that he was even called upon to rule on. And that is true. He really wasn't called upon it to rule on. And now he could have said more than he did, you know, in the final ruling. He just didn't. But the point is he wasn't called out. So while he wasn't making a decision on that, and that is crystal clear, the little asshat pricks at the SEC, they could easily argue, oh, look what the judge said, LBC security. If you use that language, it gets a little, see how it's slippery? And then the judge says, to the extent it's necessary to disabuse anybody that the order had some meaning, when I issue an order on remedy, I'll make clear that I am not taking the position that LBC is or is not a security. What I held, and all that I held, and I think the SEC acknowledges this, is that the offerings here of LBC were investment contracts, and they are subject to the registration requirement. Okay, so I'll pause it. He's just saying that what he's ruling on are specific transactions pertaining specifically to library having to do with LBC. That's it. No other transactions, no secondary market transactions, that's it. And we are still waiting on this final ruling from the judge, but based on what he stated here, as long as he keeps his word, we're going to have some very positive news when this comes out. At least this portion of it. That's what I'm expecting. I can't imagine that he'd go back on what he articulated here at the end of January. And then Attorney Deaton says, Your Honor, and that's why I'm here. And I'll sit down real soon. That's why I'm here before you and traveled, because that clarity needs to be made. It was made in telegram, and the second decision that Judge Castell out of the Southern District of New York, he stated the first time he said it, and the second time he says, you're not listening. The underlying contract is not the security. The Graham token, it's alphanumeric code. That's not the security. It is the offering, and it's the scheme. And I think that needs to be clear. Yeah, exactly. So, of course, Attorney Deaton knocking out of the park as usual. The only thing, I appreciate that Deaton was trying to nudge him in this direction. The only thing that we didn't get that would have made it that much better is if the judge would have gone so far as to state the asset itself isn't the security. But he wouldn't do that. He says that he said something along the lines of, well, I'm a minimalist, something to that effect. So he just wouldn't go quite that far. But still, even just saying, hey, secondary market transactions, of course, that's not included in this. That's golden. That's a really big deal. That's fantastic. That's a big win for XRP holders and everybody in crypto, so far as I'm concerned. And then Deaton said also, I'm asking that, Your Honor, if you do enter injunctive relief or in the clarification that you state that your ruling has nothing to do with secondary sales. So there's Deaton asking, hey, if you're going to do that, could you please just clarify that what you're ruling on doesn't include secondary sales? For the love of God, damn it. My words, not his. And then the judge says, I absolutely will intend to do that unless the SEC changes its position and argues that some of the relief I order should affect secondary sales. Now, let's pause to note here. The SEC, they're trying to be slippery as it pertains to like this idea that the asset itself is a security. Because if you look at what they argue, they might as well be arguing that, but they're not going to come right out and say that. And so I don't think, I'd be really surprised if you see the SEC change their position and say, yes, secondary market transactions are securities. That's a losing battle. If it came down to, like that's outside of the bounds of legal precedent. There's no way. There is no precedent for such things. So they could make that argument, but I don't think they will. And as long as they don't, then the judge is going to do what he said he's going to do, right? That's what I think. And then the judge says, if they stick to their current position, which is, I'm not asking you to do anything with respect to secondary sales, I'm going to make it very clear that nothing in my order has anything to do with secondary sales. So let's pause. He's going to make it crystal clear, right there, very clear. This is the words he used. That is exactly what we need. And then he says, and as I said, I have doubts about whether to grant any injunction at all here, and to the extent I don't grant any injunction at all, that part of your concern will go away because I won't be granting any injunction in any way that could be, in my view, misconstrued to apply to secondary sales. Something the SEC has expressed multiple times to me it has no desire to try to effect in this particular case. Yeah, of course, that's what they say, but they're the SEC. They are awful humans. What do you think they're going to do ultimately? They'd point to it. If they could get away with it and use tricky sounding language, as I've been citing here throughout this video, if you know that they'd bring this up in other cases. These are awful humans. Of course they would. They'd absolutely misconstrue it. So I appreciate the clarity here. At least the judge, I think he got the wrong decision, with the ruling this past November saying library lost for a number of reasons. I've gone in depth about that, so I won't in this video. But at least we've got this, and this is a big deal. For your typical crypto investor here, this is a bigger deal. We need protection for secondary market transactions. If we have that, we shouldn't have any fear then, as long as we actually end up with that, and exchanges shouldn't either. Not for those reasons, at least. So pretty cool stuff here, right? And there we are. So it's all because of Attorney Deaton. How freaking cool is this? I'm just thankful that we're at the end of our journey as it pertains, or at least in theory we are, unless there's like crazy appeals that go on for years, but I don't want to jinx it. So outside of that, I'm thankful that we're at the end of our journey as an XRP community as it pertains to all this legal stuff. More on that in a video coming up here soon. But there's so many other projects and exchanges getting attacked right now. They're just beginning their multi-year journey in this. And the SEC is basically the devil. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Boone family sedan.